Before we begin, a quick and important disclaimer. This video is intended strictly for educational and entertainment purposes and does not constitute professional legal, financial, or psychological advice. Divorce laws and regulations vary significantly by state and individual circumstances. You should conduct your own due diligence and consult with a licensed attorney or a qualified professional in your jurisdiction before making any decisions regarding your personal or legal affairs. Imagine it is 1923. If you were a woman in the United States seeking to end a marriage, you didn't just need a reason. You needed a villain. You had to prove in a court of public record that your spouse had committed a specific, egregious act: adultery, extreme cruelty, or willful desertion. Without a smoking gun, you were legally bound to a contract that dictated your social standing, your financial security, and your very identity. Fast forward to today, and the landscape has undergone a seismic shift. Yet the emotional and logistical stakes remain higher than ever. Why is it that despite a century of progress, so many women still feel like they are stepping into a minefield without a map? In the next 10 parts of this masterclass, we are deconstructing the entire architecture of divorce in America. We aren't just looking at the how-to of filing paperwork. We are examining the systemic evolution of why women are now the primary initiators of divorce in nearly 70% of cases. We are diving into the hidden history that shaped the current legal system, and more importantly, providing you with the framework to navigate a process that is designed to be adversarial. By the end of this deep dive, you will understand the intersection of historical legal trends, the modern reality of asset division, and the psychological blueprint for reclaiming your autonomy. To understand where you stand today, we have to look at the fault era. For the first half of the 20th century, the U.S. legal system viewed marriage as a permanent social pillar that only the state could dissolve under extreme duress. This created a culture of blame. If a woman wanted to leave, she often had to hire private investigators to catch a spouse in a compromising position or prove physical danger. The burden of proof was entirely on the person seeking the exit. This era didn't stop divorces. It just made them more expensive, more secretive, and more damaging to the reputation of the woman. Everything changed in 1969 when California Governor Ronald Reagan signed the first no-fault divorce law. This was the spark that ignited a nationwide revolution. It removed the requirement for a guilty party, allowing couples to cite irreconcilable differences. While this was a monumental leap for personal freedom, it also created new, complex financial challenges. We saw a historical trend where the immediate standard of living for women often dropped significantly post-divorce because the law shifted from protecting the innocent spouse to a more clinical, often colder, division of assets. Today, women face a unique set of modern pressures. We live in an era of the double burden, where women are often contributing significantly to the household income while still performing the majority of the domestic labor and mental load. This discrepancy is a frequent driver in the decision to seek a dissolution. However, the modern woman also has more tools at her disposal than her grandmother could have ever imagined. You have access to forensic accounting, mediation services, and a deeper understanding of gray divorce, the rising trend of women over 50 choosing to start over. This masterclass is your comprehensive guide to that transition. We are going to explore the potential outcomes of various filing strategies, the reality of equitable distribution versus community property, and how to manage the pre-filing phase, which is often where the most critical mistakes are made. This is about moving from a place of reactive fear to a position of informed strategy. Consider the case of State A versus State B. In a community property state like California or Texas, the law generally views all assets acquired during the marriage as owned 50/50ths by both partners. This sounds simple, but it becomes incredibly complex when you factor in premarital assets that have been commingled. For example, if you owned a home before the wedding but used joint funds to pay the mortgage for 10 years, that house is no longer strictly yours in the eyes of the court. On the other hand, in equitable distribution states like New York or Florida, the court looks at what is fair, not necessarily what is equal. This allows for a deeper dive into non-monetary contributions, such as a woman putting her career on hold to raise children or support her husband's education. Understanding these distinctions is the difference between a settlement that leaves you struggling and one that sets you up for long-term stability. We also have to address the mental load gap. Data suggests that women often spend months, if not years, emotionally processing the end of a marriage before they ever step into an attorney's office. This gives you a strategic advantage, but only if you use that time wisely. This part of the series is designed to help you synchronize your emotional readiness with your legal readiness. We will discuss the document discovery phase, which is essentially a financial audit of your life. Most women don't realize that their most powerful weapon in a divorce isn't a high-priced litigator. It's a well-organized spreadsheet. You need to track every account number, every life insurance policy, every digital asset, including cryptocurrency and loyalty points, and every debt. In the modern U.S. landscape, financial infidelity is an increasing factor in marital breakdowns. This occurs when one spouse hides debt, maintains secret accounts, or funnels joint money into private investments. We will show you how to identify the red flags of financial hiding, such as sudden changes in mail delivery, new passwords on joint accounts, or a spouse who suddenly claims the business is having a bad year, just as the marriage begins to cool. Furthermore, we are looking at the evolution of custody. A century ago, children were often viewed as the property of the father. Later, the tender years doctrine shifted the bias toward mothers. Today, the trend is toward 50-50 co-parenting as the default starting point. While this aims for fairness, it requires a level of communication that many divorcing couples find impossible. We will break down how to build a parenting plan that is bulletproof, addressing everything from holiday rotations to who pays for extracurricular activities and how to handle future romantic partners. The goal here is not just to survive the next 12 to 18 months. It is to ensure that the second act of your life is built on a foundation of clarity. Whether you are dealing with a high net worth separation, a complex custody battle, or a relatively amicable split, the information in this masterclass is designed to level the playing field. We are moving away from the victim narrative that characterized 20th century divorce and toward a narrative of strategic transition. We will examine the step-by-step process of choosing the right legal path, litigation, mediation, or collaborative divorce. Each has its own cost-benefit analysis. Litigation is public and expensive but necessary if there is high conflict or hidden assets. Mediation is private and cost-effective, but requires two people who are willing to be honest and reasonable, a rarity in many divorces. Collaborative divorce offers a team-based approach with neutral financial experts and coaches. We will provide the data you need to decide which path aligns with your specific goals. By the time we finish this 10-part series, you will have moved from uncertainty to a place of profound understanding. You will see the historical context of your rights, the modern application of those rights, and the practical steps needed to protect your future. This is part 1 of your deep dive into the century of change. Stay with us as we move into the next phase, the financial audit and the hidden assets. We are now stepping into the most critical phase of the process, the financial audit and the investigation of hidden assets. In the year 2026, the complexity of a household balance sheet has evolved far beyond the simple joint checking account and a physical deed to a house. Today, your financial footprint is digital, global, and often fragmented across dozens of platforms. If you are entering this process without a comprehensive map of every dollar that has flowed through your marriage, you are essentially flying blind. We are going to break down the exact mechanics of how financial discovery works in a modern U.S. divorce, the historical trends of asset concealment, and the technical steps you can take to ensure transparency. Consider the scenario of Sarah, a fictional but representative professional in Chicago. Sarah had been married for 15 years. Her spouse handled the primary investments while she managed the daily household operations and her own career. When the conversation of divorce began, the initial disclosure showed a standard portfolio, a 401k, a primary residence, and 2 vehicles. However, historical trends in high-stakes divorces suggest that what is on the surface is rarely the full story. By utilizing a forensic approach, Sarah discovered that over the preceding 24 months, small, recurring increments of cash had been moved into a digital wallet for cryptocurrency, and that a secondary brokerage account had been opened in the name of a limited liability company that her spouse had quietly registered in a different state. This is not just a story of deception. It is a case study in why the discovery phase is the backbone of your legal standing. The first step in your financial audit is the assembly of the paper trail. In the 1980s, this meant digging through filing cabinets and shoeboxes. In 2026, this means securing your digital access. You must compile at least 5 years of federal and state tax returns. These documents are the Rosetta Stone of a marriage. They reveal reported income, business losses, and interest in foreign accounts that might otherwise go unmentioned. You are looking for discrepancies between the lifestyle you lived and the income reported to the IRS. If the tax returns show a modest income but your household expenses were significantly higher, that is a red flag indicating potential untaxed income or hidden cash reserves. Next, we look at the concept of commingling and separate property. This is where many women lose significant leverage. Imagine if you inherited $50,000 from a relative 5 years ago. If you kept that money in a separate account in your name only and never touched it, it is likely considered separate property in most jurisdictions. But the moment you move $10,000 from that account to pay for a new roof on the marital home, you may have commingled those funds. In many states, once a separate asset is mixed with marital assets, it can be transmuted into marital property, meaning your spouse may now be entitled to half of it. The audit requires you to trace every major deposit back to its source to prove its original status. Now we must address the modern frontier: digital assets and the shadow economy. In 2026, a significant portion of marital wealth may exist in forms that do not produce a monthly paper statement. This includes cryptocurrency, non-fungible tokens, and even high-value digital collectibles. It also includes fintech accounts like Venmo, PayPal, or Cash App. Case studies have shown that spouses often use these platforms to leak money out of the marital estate. They might send $500 to a friend for a fake debt, with the understanding that the friend will return the cash after the divorce is finalized. Your audit must include a line-by-line review of these digital payment histories. You are looking for patterns, round numbers, frequent transfers to the same individual, or payments to vendors you do not recognize. Then there is the issue of deferred compensation and executive perks. If your spouse works in a corporate environment, their true value to the household is often hidden in restricted stock units, stock options, and unvested bonuses. Historical trends show that many spouses attempt to argue that because these assets haven't vested yet, they should not be included in the divorce settlement. However, in the US, if the work to earn those options was performed during the marriage, the marital estate typically has a claim to a portion of them. You must obtain the specific grant agreements and vesting schedules from the employer. Without these, you could be leaving hundreds of thousands of dollars on the table that will only manifest years after the divorce is final. The audit also extends to the lifestyle analysis. This is a step-by-step reconstruction of your actual cost of living. You need to calculate every expense from the last 3 years, from the mortgage and insurance down to the cost of hair appointments, streaming subscriptions, and pet care. This data is vital for 2 reasons. First, it establishes the standard of living maintained during the marriage, which is a primary factor in determining potential outcomes for alimony or spousal support. Second, it serves as a check against the disclosed income. If your spouse claims to earn $100,000 a year, but your lifestyle analysis shows you were spending $150,000, the court will want to know where the extra $50,000 originated. One of the most complex areas of the modern audit is the valuation of closely held businesses. If you or your spouse owns a business, its value is not just what is in the bank account. It includes goodwill, intellectual property, and future earning potential. Spouses who own businesses often have the ability to manipulate their income by overpaying expenses or delaying the billing of clients until after the divorce. A professional audit looks for non-business expenses paid through the company, such as personal travel, meals, or vehicle leases. These are essentially add-backs that increase the true income available for support calculations. Step by step, you should create a master asset list. This document should include the account name, the last 4 digits of the account number, the current balance, and the date of that balance. You should also note whether the asset was acquired before or during the marriage. Do the same for liabilities, mortgages, car loans, credit card debt, and student loans. Remember, in many states, debt incurred during the marriage is shared, even if your name isn't on the credit card. Understanding the total debt load is just as important as understanding the total assets, as it affects the net value you will actually receive. The psychology of this phase is intense. Feels like detective work because, in many ways, it is. But the goal is not to be malicious. It is to be accurate. The legal system in the United States operates on the principle of full and fair disclosure. If one party fails to disclose an asset, and it is discovered later, many states have laws that allow the court to award the entirety of that asset to the other spouse as a penalty. By being meticulous now, you are protecting your future self from the fallout of an incomplete settlement. As we conclude this deep dive into the financial mechanics, you might be wondering, what happens once I have all this data? How do I actually use this information to ensure my day-to-day life doesn't collapse while the legal battle rages? The paper trail is only half of the equation. The other half is the immediate, tactical protection of your physical and digital security. In the next part, we are going to look at the immediate first strike actions, the steps you must take within the first 48 hours of deciding to file to secure your credit, your communications, and your physical safety. We will explore how to set up a war chest without triggering a legal backlash, and how to handle the sudden shift in social and digital privacy. If you think the financial audit was detailed, wait until you see the blueprint for your personal security transition. The moment the decision to divorce moves from a private thought to a legal reality, a clock starts ticking. This is the transition from domestic partnership to a tactical legal environment. In 2026, the first 48 hours are no longer just about who sleeps on the couch. They are about securing your digital perimeter and establishing a financial lifeline. Historical trends in the United States show that the initial actions taken during this window can significantly influence the potential outcomes of the entire proceeding. If you act impulsively, you risk being accused of asset dissipation or bad faith. If you fail to act, you risk being locked out of your own life. Imagine the situation of Maria in Miami. In early 2026, Maria realized her marriage was over. Before saying a word to her spouse, she conducted a digital security sweep. She realized that her husband had access to her location through a shared family plan on her smartphone, her vehicle's built-in GPS, and even through the smart home security system. He could see when she left, where she went, and who entered the house. Maria's first step wasn't calling a mover. It was securing her data. This is the blueprint for the modern personal security transition. The first pillar is digital sovereignty. In a modern U.S. household, your lives are intertwined through shared clouds, family accounts, and synchronized devices. Step 1 is changing every single password to your primary accounts, email, banking, and social media. However, you must be careful. In many jurisdictions, courts look unfavorably on a spouse who suddenly cuts off the other from shared services like the home internet or cellular data during the separation. The goal is to secure your private communications, not to sabotage the other party's connectivity. Use a password manager that your spouse has no access to and implement two-factor authentication using a secondary authentication app rather than SMS, as shared phone plans can sometimes allow a primary account holder to view incoming text logs. Step 2 involves the immediate creation of a communication log. From this moment forward, every interaction with your spouse should be viewed as a potential exhibit in a courtroom. Many women in the US are now moving their primary communication to specialized co-parenting apps or encrypted platforms that maintain an unalterable record of messages. If your spouse has a history of high-conflict behavior, stop taking phone calls. Move everything to writing. This isn't about being cold. It's about creating a factual history. If a spouse makes a threat or admits to hiding an asset in a text message, that is a data point that your legal team can use. The second pillar is the financial war chest. There is a delicate balance between protecting yourself and appearing to loot marital funds. Historical trends suggest that courts generally allow a spouse to withdraw up to half of the funds in a joint checking account to cover immediate living expenses and a legal retainer, but this varies wildly by state. A case study from a 2025 New York filing showed that a wife who emptied the entire joint savings account of $200,000 was ordered by a judge to return the funds within 48 hours and pay her husband's legal fees for the motion. The tactical move is to open a new, individual bank account at an entirely different financial institution. Do not open it at the same bank where you have joint accounts, as bank employees have been known to accidentally link profiles or allow a spouse to see a new account's existence through a shared portal. Once this account is open, redirect your future income, whether it is your salary, freelance payments, or investment dividends, into this new private account. This ensures you have liquid capital that cannot be frozen by an angry spouse. Simultaneously, you should pull a fresh copy of your credit report. In the US, your credit score is your lifeline to independence. You need to know exactly what debt is in your name, what is joint, and if there are any accounts you didn't know existed. If you are an authorized user on your spouse's credit cards, be aware that they can remove you at any time, leaving you without a way to pay for groceries or gas. Securing your own line of credit, while you still have a household income to report, is a common strategic step. The third pillar is physical and environmental security. If there is any history of domestic volatility, this is the most critical step. In 2026, technology is often used as a tool for tech-enabled stalking. You must check your vehicle for AirTags or similar tracking devices. You should also audit your social media presence. In the US legal system, your digital footprint is discoverable. That photo of you out at a high-end dinner with friends could be used in court to argue that you don't need spousal support because you have plenty of discretionary income. The rule for the first 48 hours is: go dark. Stop posting. Revoke permissions for third-party apps that share your location. Now let's talk about the War Room Assembly. You are not just hiring a lawyer, you are building a team. For a modern woman in the US, this team often includes a family law attorney, a financial planner, and sometimes a therapist or a divorce coach. Why a coach? Because your attorney bills by the hour, and using them as an emotional sounding board is a fast way to deplete your retainer. A case study of a high-net-worth divorce in Seattle showed that the wife saved nearly 30% in legal fees by using a divorce coach to handle the emotional logistics and a financial neutral to organize the discovery documents, leaving the attorney to focus solely on the legal strategy and court filings. There is also the matter of the marital home. One of the biggest misconceptions in U.S. divorce law is that if you leave the house, you abandon your right to it. This is rarely true in a legal sense, but leaving can have a massive impact on custody and temporary support orders. If you leave the children behind, you may inadvertently set a status quo, where the other parent is the primary caregiver, which can be very difficult to overturn later. Unless there is a physical safety risk, many attorneys advise their clients to stay in the home until a temporary orders hearing can establish who lives where and who pays which bills. As you navigate these first 48 hours, you will feel a massive amount of pressure to get it over with. This is a trap. The legal system moves slowly, and the decisions you make while under the influence of extreme stress or a desire for peace at any price can haunt you for a decade. Every document you sign and every agreement you make regarding the children or the finances during this initial shock phase should be considered temporary and reviewed by counsel. We are moving into an era where the sovereign woman is the one who understands that her greatest asset is information. By securing your digital world, establishing your financial independence, and assembling a professional team, you are no longer a passenger in your own divorce. You are the lead strategist. But even with the perfect strategy, there is one area that remains the most volatile, the most emotional, and the most prone to legal deadlock. In the next part, we're going to dive into the modern reality of custody and the best interests of the child standard in 2026. We will look at the rise of birdnesting, where the children stay in the house and the parents rotate in and out, and how the U.S. court system handles the relocation trap. If you have children, the next part of this masterclass is the most important 1,000 words you will ever read, because it's where the strategy meets the heart. The landscape of child custody in the United States has undergone a radical transformation since the mid-20th century, moving away from the maternal preference and toward a standard focused entirely on the best interests of the child. In 2026, this standard is applied through a lens of psychological stability, educational continuity, and the quality of the parent-child bond. If you are a mother navigating this, you must understand that the court is no longer looking for the better parent. It is looking for the parent most likely to facilitate a healthy relationship with the other parent. This is a subtle but profound shift in legal strategy that catches many off guard. Imagine the case of Elena, a mother in Phoenix who had been the primary caregiver for her 2 children for a decade while her spouse traveled for work. In the past, Elena might have assumed that her role as the primary nurturer naturally translated to primary physical custody. However, under the modern best interests standard, her spouse argued that his new remote work lifestyle in 2026 allowed him to be equally present. The court didn't focus on who changed the most diapers in 2018. It focused on who could provide a stable environment in 2027 and beyond. This case study highlights why you must document the current daily reality of your children's lives with clinical precision. The first concept to master is the distinction between legal custody and physical custody. Legal custody refers to the right to make major decisions about a child's life, education, healthcare, and religious upbringing. In the vast majority of modern U.S. cases, historical trends show that courts favor joint legal custody. This means even if the children live with you 90% of the time, you cannot change their school or schedule a non-emergency surgery without your ex-spouse consent. Physical custody, on the other hand, dictates where the child actually sleeps. We are seeing a massive rise in 50-50 shared physical custody schedules, such as the 2-2-3 rotation or week-on week-off. While this is intended to be fair to parents, its success depends entirely on the proximity of the 2 homes and the parent's ability to co-parent without high conflict. This brings us to a modern trend gaining significant traction in 2026, Birdnesting. Imagine if, instead of the children packing suitcases every Sunday, they stayed in the family home while you and your ex-spouse rotated in and out of a separate apartment. For many families, this offers a potential outcome where the children's lives remain virtually unchanged during the most volatile part of the divorce. However, birdnesting requires immense financial resources and a high level of mutual trust. It is often a temporary solution, a bridge to help children adjust before the family home is eventually sold or one parent moves permanently. A critical trap in modern custody battles is the relocation clause. In our highly mobile 2026 society, the desire to move back to your hometown or follow a new job opportunity is common. But if you have a joint custody order, moving even 50 miles away can be legally classified as a relocation that requires court approval. If the move is deemed to interfere with the other parent's visitation rights, the court may deny the move or, in extreme cases, transfer primary physical custody to the parent who is staying put. Before you make any plans to relocate, you must analyze the specific distance thresholds in your state statutes. Now let's talk about the step-by-step construction of a parenting plan. In the U.S., a vague reasonable visitation clause is a recipe for disaster. A professional-grade parenting plan in 2026 is a 50-page document that covers every conceivable variable. You must specify who is responsible for transportation and where the exchanges occur. Are they in a public place? At the school? You must define how holidays are split, not just Christmas and Thanksgiving, but Monday holidays like Memorial Day and Labor Day. What happens if a child is sick on the other parent's day? What is the right of first refusal? Which dictates that if one parent needs a babysitter for more than 4 hours, they must first offer that time to the other parent. Data from family court filings suggest that the more detailed the initial plan, the lower the likelihood of returning to court for modifications. You should also include a social media and technology clause. In an era of smartphones and social media, you need to agree on what age the children can have accounts, who monitors them, and whether either parent is allowed to post photos of the children without the other's consent. This is a common flashpoint in 2026 that did not exist 20 years ago. Another vital area is the role of the guardian ad litem, or a court-appointed evaluator. If you and your spouse cannot agree on a schedule, the court may appoint a professional to represent the child's interests. This person will interview the parents, the children, teachers, and doctors. They will conduct home visits. Historical trends indicate that judges lean heavily on the recommendations of these evaluators. Your strategy during an evaluation is not to disparage the other parent. In fact, if you appear overly critical or alienating, it can backfire. The most successful potential outcomes occur when a parent demonstrates that they are the gatekeeper, who encourages the child's relationship with the other parent, while still maintaining clear boundaries and structure. We must also address the financial component of custody, which is child support. While every state has a formula, often based on the income of both parents and the number of overnights each has, there are extraordinary expenses that formulas often miss. In 2026, this includes high-speed internet for schooling, private tutoring, mental health therapy, and club sports that can cost thousands of dollars a year. Your parenting plan must explicitly state the percentage of these costs each parent will bear. Relying on a verbal agreement to split things 50-50 is not enforceable and often leads to the earning spouse carrying the bulk of the burden. Step by step, you should also prepare for the possibility of co-parenting therapy. This is a growing requirement in many U.S. jurisdictions for high-conflict cases. The goal is to move the relationship from an emotional one to a business-like one. You are no longer partners. You are co-executives in the corporation of your children's lives. This mindset shift is the single most important factor in long-term success. It protects the children from the toxic stress of parental conflict, which data shows is the primary predictor of poor outcomes for children of divorce, rather than the divorce itself. As you look at your children and wonder how this will reshape their future, remember that the legal system is a tool, but your behavior is the environment. The century of change has given women the right to pursue a life of autonomy without losing their children, but it has also placed a premium on the ability to navigate a complex, bureaucratic system. You are building the framework for their childhood and your own peace of mind. But as you secure the heart of your home, the reality of the alimony cliff begins to loom. How do you support this new life? In an era where lifetime alimony is almost extinct in the United States, how do you bridge the gap between being a stay-at-home parent and a self-sufficient professional? In the next part, we are going to dissect the brutal and often misunderstood world of spousal support in 2026. We will look at the rehabilitative alimony trend and the specific tactics used to calculate your earning capacity, even if you haven't worked in a decade. If you think custody was complex, the battle for your financial future is about to get even more intense. We are now entering the realm of spousal support, a concept that has evolved from a permanent lifelong obligation to a highly structured, time-bound bridge toward independence. In the U.S. legal system of 2026, the term alimony has largely been replaced by maintenance or spousal support, reflecting a shift in philosophy. The courts no longer view support as a pension for a former spouse, but rather as a tool to equalize the economic impact of the divorce, specifically for women who may have sacrificed their own earning potential for the benefit of the family unit. To navigate this, you must understand the mathematical and psychological shift from permanent support to what is now known as rehabilitative maintenance. Imagine the case of Julia, a woman in Atlanta who spent 20 years as a stay-at-home mother, while her husband built a successful medical technology firm. In 1976, Julia might have expected permanent alimony that would sustain her lifestyle indefinitely. In 2026, however, the court looks at Julia's situation through the lens of earning capacity and vocational transition. Julia's legal team must demonstrate not just her current lack of income, but the specific economic cost of her 20-year career hiatus. This is a crucial distinction. We are looking at historical trends where the focus has shifted toward how long it will take Julia to gain the skills necessary to become self-sufficient. The first step in calculating spousal support is the determination of need versus the ability to pay. This sounds straightforward, but in a deep dive analysis, it involves a granular review of both parties' financial affidavits. The court examines the standard of living established during the marriage. If you lived in a $5 million home and traveled internationally 4 times a year, the court recognizes that you cannot be expected to move into a studio apartment overnight. However, ability to pay is the ultimate ceiling. If the high-earning spouse's income has plateaued, or if the division of assets has left them with significant debt, the potential outcomes for a high support award decrease. Next, we must analyze the vocational evaluation. In 2026, it is common for the higher-earning spouse to hire a vocational expert to testify against you. This expert will look at your education, your past work history, and the current job market in your specific U.S. city. They might argue that even though you haven't worked in 15 years, your degree in marketing from 2008 makes you capable of earning $70,000 a year today. This is the earning capacity trap. To counter this, you must provide step-by-step evidence of why that capacity is not immediate. This includes the cost of recertification, the technological gap in your skills, and the childcare responsibilities that may limit your hours. There are generally 3 types of support you need to be aware of. First is temporary maintenance, often called pendant light. This is ordered at the very beginning of the divorce process to ensure that bills are paid while the case is pending. Second is rehabilitative maintenance, which is the most common form in the United States today. This is support paid for a specific period, perhaps 3 to 7 years, intended to cover the time it takes for you to finish a degree or gain work experience. Third is durational or permanent maintenance, which is increasingly rare and usually reserved for long-term marriages, typically 20 years or more, where one spouse is of an age or health status that makes self-sufficiency impossible. A critical factor in 2026 is the tax treatment of spousal support. Following the Tax Cuts and Jobs Act, the federal tax rules changed significantly. In the U.S., for any divorce finalized after December 31, 2018, alimony is no longer deductible for the person paying it, and it is not considered taxable income for the person receiving it. This changed the negotiation dynamics entirely. In the past, high earners were willing to pay more because they got a tax break. Now, every dollar they pay is a post-tax dollar, making them fight much harder to keep that number low. You must work with a financial professional to calculate the net value of your support award to ensure it actually covers your projected expenses. Step by step, you must also prepare for the marital misconduct variable. While we live in a no-fault era, some U.S. states still allow the court to consider financial misconduct or egregious fault when determining support. If a spouse spent significant marital funds on an affair or a gambling addiction, the court might increase the support award to compensate the other spouse for that loss of marital equity. Conversely, if the spouse seeking support has committed similar acts, it could potentially lower their award. You need to gather bank statements and credit card receipts that show any dissipation of assets. Another modern reality is the cohabitation clause. Almost every spousal support agreement in 2026 includes a provision that payments end if the recipient remarries or cohabitates with a new partner in a relationship analogous to marriage. This is a high-stakes area of litigation. Private investigators are frequently used to prove that a former spouse has moved a significant other into their home to trigger a termination of support. If you are receiving support, you must be extremely cautious about how your future relationships are structured legally and financially. We also have to discuss the lifestyle analysis in relation to alimony. This is not just about your rent and groceries. It includes your ability to continue saving for retirement. A common mistake women make in settlement negotiations is focusing on their immediate cash flow, while ignoring their long-term capital needs. If you receive $5,000 a month in support but can no longer contribute to a 401k or an IRA, you are essentially depleting your future for your present. A deep dive strategy involves negotiating for a buyout of alimony, a lump sum payment at the time of divorce that you can invest immediately, rather than relying on monthly checks that could be stopped if your ex-spouse loses their job or passes away. Finally, there is the issue of enforcement. A court order for support is only as good as the recipient's ability to collect it. In the US, we have seen a historical trend of strategic underemployment, where a spouse suddenly quits a high-paying job or takes a lower salary to reduce their support obligation. In these cases, the court can impute income, meaning they will base the support amount on what the spouse should be earning, not what they claim to be earning. To prove this, you need a history of their past earnings, bonus structures, and even LinkedIn activity that shows they are turning down lucrative opportunities. The transition from a two-income or high-resource household to an independent one is a monumental task. The spousal support phase is where the century of change is most visible. It represents the tension between the old world of dependency and the new world of self-actualization. You are not just fighting for a check. You are fighting for the time and resources to rebuild your professional identity. But once the income is settled and the support is negotiated, you face the most permanent division of all: the retirement accounts and the family home. In the next part, we are going to look at the Qualified Domestic Relations Order, or QDRO, the secret legal instrument that divides pensions and 401ks without triggering massive IRS penalties. We will also tackle the emotional and financial trap of the house at all costs mentality. Is keeping the family home a victory? Or is it a financial anchor that will sink your future? The answer is more complex than you think, and it's the focus of Part 6. The family home is more than just a piece of real estate. It is a repository of memories, a symbol of stability, and often the single largest asset in a marital estate. In the United States in 2026, the decision to keep or sell the home is where emotional sentiment and cold financial logic collide most violently. Historical trends show that many women fight tooth and nail to keep the residence, primarily to maintain a sense of normalcy for their children. However, a case study from a 2025 settlement in Denver illustrates the house at all costs trap. A mother, whom we will call Linda, successfully negotiated to keep the family home valued at $800,000. In exchange, she waived her rights to her husband's equivalent 401k and pension plans. 2 years later, Linda found herself house poor. She had the equity, but she lacked the liquidity to pay for a sudden roof repair, rising property taxes, and the increased cost of utilities. This is the danger of an illiquid asset. When you look at the family home, you must look beyond the current market value. You have to calculate the carrying cost, which includes the mortgage, homeowners association fees, insurance, and the relentless reality of maintenance. In 2026, with fluctuating interest rates and the rising cost of home services in the US, if the carrying costs exceed 30% of your new single-income budget, the home may transition from a sanctuary to a financial anchor. If you do decide that keeping the home is the right move for your specific circumstances, you must understand the mechanics of the equity buyout. This is not as simple as handing over a check. In the US, this typically requires a refinance in your own name. This means you must qualify for a mortgage based solely on your own income and credit score. If you have been out of the workforce or have a lower income, a lender may not approve the loan regardless of how much equity is in the dirt. Step by step, you should meet with a mortgage broker specializing in divorce early in the process to determine your borrowing power. If you cannot refinance, you may be forced to sell the home anyway, but now under the pressure of a court deadline, which is the worst possible time to be a seller. Now let's pivot to the invisible wealth, retirement accounts, and the Qualified Domestic Relations Order, commonly known as a QDRO. In the century of change, the way we save for the future has shifted from corporate pensions to individual 401k and 403b plans. Many women believe that because a 401k is in their spouse's name, it belongs solely to that spouse. This is a significant misconception in U.S. family law. In most states, any contributions made to a retirement account during the marriage are considered marital property. The QDRO is the legal key that unlocks these funds. It is a specific court order that instructs a plan administrator to divide a retirement account into two separate accounts without triggering the 10% early withdrawal penalty or immediate income tax. Imagine if your spouse has $500,000 in a 401k. A QDRO allows the plan to move $250,000 into a new account in your name. You can then roll that over into your own IRA. However, the step-by-step drafting of a QDRO is highly technical. If the wording is slightly off, the plan administrator will reject it, and you may find yourself back in court months or even years after the divorce is finalized. You must ensure that your settlement agreement specifies who pays for the QDRO preparation, and that it accounts for market gains or losses between the date of separation and the date of distribution. We also have to address the complex world of pensions. While rarer in the private sector in 2026, they are still prevalent for government employees, teachers, and military personnel. Dividing a pension is vastly different from dividing a 401k. A pension is a stream of future income, not a current pile of cash. You have to decide between a shared interest or a separate interest. A shared interest means you get a check only when your ex-spouse retires. A separate interest allows you to start receiving your portion based on their earliest retirement age, regardless of when they actually stop working. Historical trends in U.S. military divorces show that many women lose out on significant retirement benefits because they didn't understand the 10-10 rule, which affects how the Defense Finance and Accounting Service handles direct payments to a former spouse. Then there is the issue of Social Security. If you were married for at least 10 years and are currently unmarried, you may be entitled to claim Social Security benefits based on your ex-spouse's earnings record once you reach retirement age, provided those benefits are higher than your own. The crucial detail here is that claiming these benefits does not reduce the amount your ex-spouse receives, nor does it affect the benefits of their new spouse if they remarry. This is a federal benefit, not a marital asset divided by a state judge, but it is a critical piece of your long-term financial puzzle that must be factored into your post-divorce projections. As we analyze the division of these complex assets, we must also look at the potential outcomes of capital gains tax. If you sell the family home as part of a divorce, you and your spouse may be eligible for a $500,000 capital gains exclusion if you sell while still legally married and filing jointly. If you wait until after the divorce is final and you own the home alone, your exclusion drops to $250,000. In a high-value real estate market like California or Florida, this 5-figure or 6-figure tax difference can be a massive factor in deciding the timing of your sale. The division of assets is a mathematical exercise, but it is also a strategic one. You have to decide which dollars are the most valuable. A dollar in a savings account is worth a full dollar. A dollar in a 401k might be worth only 70 cents after you eventually pay taxes on it. A dollar of equity in a home is worth even less once you factor in the 6% realtor commission and closing costs you will eventually pay to get that dollar out. A professional lifestyle analysis in 2026 requires you to look at the tax-adjusted value of every asset on the table. Step by step, you should create a side-by-side comparison of your settlement options. Option A might give you the house but no retirement. Option B might give you half the retirement, a smaller apartment, and a cash buyout. When you run the numbers 10 years into the future, the potential outcomes often favor the person who took the liquid assets and the retirement accounts over the person who stayed in the big house. This is the hardest part of the masterclass because it requires you to grieve the home while you are still living in it. But even after the assets are divided and the QDROs are signed, there is a shadow that often lingers over the entire process. It is the hidden cost of the adversarial system itself. As we move into the final stages of this deep dive, we have to look at the psychological warfare that can erupt during the final negotiations. How do you handle a spouse who uses the legal process to continue a cycle of control? In the next part, we are going to explore the reality of legal abuse and narcissistic tactics in the courtroom. We will look at how to identify the signs of a high-conflict personality and the specific communication strategies, like the gray rock method, that can save your sanity and your legal budget. If you feel like your divorce is becoming a battle of wills rather than a legal process, Part 7 will give you the psychological armor you need to finish the fight. We are now entering the most psychologically demanding phase of the entire masterclass, navigating high-conflict personalities and the phenomenon of legal abuse. In the United States legal system of 2026, while the laws are designed to be objective, the process itself is inherently adversarial. This structure can be exploited by individuals who view the divorce not as a dissolution of a contract, but as a battlefield for control. Historical trends indicate that as women have gained more financial and legal autonomy over the last century, certain high-conflict dynamics have shifted from physical control to what is now recognized as litigation abuse. This involves using the court system as a tool for harassment, stalling, and financial depletion. Imagine the situation of Chloe, a professional living in Austin. Chloe decided to end her marriage after years of emotional volatility. Her spouse, who had a history of controlling behavior, responded not by negotiating, but by filing over 20 different motions in 6 months. He demanded exhaustive discovery for accounts Chloe didn't own, canceled scheduled mediations at the last minute, and sent hundreds of aggressive emails daily. This is a classic case study of a high-conflict divorce where the goal of the opposing party is not a fair settlement, but the total exhaustion of the other spouse's resources and spirit. To survive this, your first step is understanding the gray rock method. This is a communication strategy designed to make you as uninteresting as a gray rock to a high-conflict individual. In 2026, with the constant connectivity of smartphones and social media, a high-conflict spouse feeds on your emotional reactions. If they send an inflammatory text and you respond with a long defense, they have won because they have engaged you. Step by step, the gray rock method requires you to give short, non-committal, and purely factual answers. If they ask a question about the kids, you provide the time and location of the pickup. If they insult your character, you do not respond. You become a dull, non-reactive surface. This deprives them of the emotional supply they seek, and often forces them to move on or reveal their true nature to the court through their increasingly desperate attempts to get a rise out of you. Next, we must address the reality of litigation abuse. This is a strategic use of the legal system to cause distress. In the US, this often looks like discovery abuse, where one side makes absurdly broad requests for documents just to increase your attorney's fees. Or it might be motion abuse, where they file unnecessary requests for hearings on trivial matters. To counter this, your legal team must be proactive. Historical trends show that judges in 2026 are becoming more aware of these tactics. Your attorney can file for protective orders or ask the court to award attorney fees as a sanction for frivolous filings. However, you must document every instance. Keep a detailed log of every canceled appointment, every late payment of temporary support, and every harassing communication. This data is the only way to prove a pattern of abuse to a judge who only sees you for 15 minutes at a time. We also have to discuss the concept of gaslighting in the legal context. A high-conflict spouse may attempt to rewrite history during the discovery phase, claiming you were never a primary caregiver, or that certain assets were gifts to them alone. Imagine if you are told repeatedly that you are crazy for remembering a specific financial transaction. In the US court system, memory is considered subjective, but records are objective. This is why the financial audit we discussed in Part 2 is your psychological anchor. When a spouse claims an account doesn't exist, and you hold the statement in your hand, the gaslighting loses its power. You must rely on the evidence, not the narrative being pushed by the other side. Step by step, you must also manage your legal team's exposure to the conflict. A common trap for women in high-conflict divorces is using their attorney as a shield for every single interaction. While your attorney is there to protect you, every email they read and every phone call they take on your behalf costs you money. In 2026, many women are utilizing specialized communication apps like Our Family Wizard or Talking Parents. These platforms are often court-ordered because they maintain an unalterable, time-stamped record of all communication. They also include tone meters that can flag aggressive language before a message is sent. Using these tools creates a buffer zone that protects your mental health and provides a clean record for the court. Now, let's look at the potential outcomes of a psychological evaluation. In high-conflict custody cases, the court may order a 730 evaluation or a similar mental health assessment of both parents. This is a deep dive into your personality, parenting style, and mental health history. If you are dealing with a spouse who has a personality disorder, they are often experts at impression management, appearing calm and charming to the evaluator while painting you as the unstable one. Your strategy here is not to diagnose your spouse. You are not a doctor. Instead, focus on describing specific, observable behaviors and the impact those behaviors have on the children. Use the data you have collected. If you say he is a narcissist, you sound like you are venting. If you say he has missed 70% of his scheduled weekend visits over the last 4 months, you are providing the evaluator with a fact they can use in their report. Another critical area is parallel parenting. In a standard divorce, the goal is co-parenting, which requires high levels of communication and cooperation. In a high-conflict divorce, co-parenting is often impossible and even dangerous. Parallel parenting is a model where each parent has total autonomy during their time with the children. There are no shared birthday parties, no joint school meetings, and communication is limited to emergencies. This is a strategic retreat that minimizes contact and therefore minimizes conflict. While it may feel sad for the children initially, data suggests that children fare much better with two parents who don't speak than with two parents who are constantly at war. As we move through these psychological trenches, you must also protect your reputation. In the digital age, a high-conflict spouse may take the battle to social media or your professional circle. This is why a social media injunction is a common part of temporary orders 26. This legally prohibits both parties from posting anything about the divorce, the children, or each other online. If your spouse violates this, it is a contempt of court. You must resist the urge to defend yourself in the court of public opinion. The only court that matters is the one with the judge. The psychological armor you are building isn't about becoming hard or unfeeling. It is about creating a boundary that the conflict cannot cross. You are learning to separate your identity from the legal process. Historical trends show that women who successfully navigate high-conflict divorces are those who treat the case like a business liquidation. They remove the emotion from the transactions and focus on the long-term goal of independence. But as the battle in the courtroom reaches its peak, another pressure begins to mount. It is the pressure of the clock. How long can you sustain this? How do you know when to settle and when to keep fighting? The endgame of a divorce is a high-stakes negotiation where the final signatures determine your life for the next 20 years. In the next part, we are going to break down the art of the settlement negotiation. We will look at the brackets of compromise, how to use mediators' proposals, and the specific tactics used to close the gap when both sides feel they have given up too much. We will explore how to secure your final decree, so that it is actually enforceable, preventing the need for future litigation. If Part 7 was about surviving the fight, Part 8 is about winning the peace. The transition from the chaos of litigation to the finality of a settlement is perhaps the most delicate maneuver in the entire divorce process. In the United States in 2026, over 90% of divorce cases are resolved before they ever reach a final trial. This is not because the parties suddenly find common ground, but because the settlement negotiation is a highly engineered environment designed to force a resolution. Winning the peace is not about getting everything you want. It is about securing a deal that is enforceable, sustainable, and final. You are effectively drafting the Constitution for your future life, and every word in that document will have financial and legal consequences for decades to come. Imagine the case of Monica, a software executive in San Francisco. After 18 months of high-conflict litigation, Monica found herself in a mandatory settlement conference. The gap between her offer and her spouse's was $300,000 in liquid assets and a dispute over the tax liability of a joint investment. To the uninitiated, this looks like a stalemate. But in the art of the settlement, Monica's team used a technique called the bracketed proposal. Instead of arguing over a single number, they proposed ranges of compromise. By shifting the conversation from specific figures to logical frameworks, they were able to bridge a 6-figure gap in less than 4 hours. This case study illustrates that the final settlement is less about emotion and more about the strategic trade of value. The first step in winning the peace is understanding the mediation framework. In 2026, most U.S. courts require mediation before granting a trial date. You will likely be in a different room than your spouse, with a neutral mediator shuttling back and forth. This is known as shuttle diplomacy. The mediator's job is not to be fair. Their job is to get a signature. You must be prepared for the mediator's proposal. This happens when both sides are stuck, and the mediator suggests a middle ground solution that they believe both parties can live with, even if they both hate it. You need to have your walk-away number firmly established before you enter this room. This is the absolute minimum you require for financial security, calculated during your lifestyle analysis in Part 5. If a proposal falls below this number, You must be prepared to walk out and head to trial, even if it is more expensive in the short term. Next, we must deconstruct the settlement agreement itself. In the legal world of 2026, a vague agreement is a gateway to future lawsuits. You must insist on specificity in enforcement. For example, rather than saying the house will be sold as soon as possible, the agreement must state that the house will be listed with a specific brokerage by a specific date, at a specific price point, and that any offer within 5% of the asking price must be accepted. Historical trends show that without these self-executing clauses, a disgruntled spouse can stall a sale for years, effectively locking up your equity. You are looking for potential outcomes where the document enforces itself without you having to hire an attorney to file a contempt motion every time a deadline passes. A major pillar of the modern settlement is the tax indemnification clause. Many women in the U.S. forget that they are still on the hook for joint tax returns filed during the marriage. If the IRS audits a return from 2024 and finds that your spouse underreported income, you are jointly and severally liable for the debt, even if you are now divorced. Your settlement must include a hold harmless provision. This means that if the IRS comes calling for issues related to your spouse's business or separate income, your spouse is legally obligated to pay the debt, the interest, and your legal fees to fight it. Without this, your settlement could be wiped out by a single tax audit 3 years down the line. Step by step, you also need to address the life insurance requirement. If you are receiving child support or spousal maintenance, those payments end if your ex-spouse passes away. In 2026, a standard protection strategy is to require the paying spouse to maintain a life insurance policy with you as the irrevocable beneficiary, in an amount sufficient to cover the total remaining value of the support. You must also include a provision that allows you to receive annual proof that the premiums have been paid. Case studies have shown that without this verification, a spouse may let the policy lapse, leaving the recipient with zero financial recourse if tragedy strikes. Now let's look at the finality of assets and the personal property trap. While you are focused on 401ks and houses, the negotiation can often derail over stuff: the artwork, the furniture, the jewelry. The strategic move in 2026 is to use a binding appraisal for high-value items and a two-list method for the rest. One spouse creates two lists of equal value, and the other spouse gets first pick of which list they want. This forces the person creating the list to be incredibly fair. Don't waste $5,000 in legal fees arguing over a $2,000 sofa. This is the time for cold, hard prioritization. Another critical area is the future modification clause. In the U.S., child support and sometimes alimony are modifiable based on a substantial change in circumstances. If your spouse is an entrepreneur, they might claim their income has dropped 6 months after the divorce. To protect yourself, your settlement should include a discovery provision that requires both parties to exchange tax returns and W-2s every year on a specific date, such as May 1st. This keeps both parties honest and prevents the need for a subpoena every time you suspect their income has increased. As the negotiation reaches its final hours, you will experience a phenomenon known as decision fatigue. The other side knows that after 10 hours of mediation, you just want to go home and see your kids. This is when the small but damaging concessions are often snuck into the language. You must have a final review period. Never sign a settlement agreement in the room the moment it is drafted. Take it home. Read it when you are rested. Have a fresh set of eyes, perhaps your financial planner. Look at the math one last time. Historical trends show that the most significant errors in divorce settlements, typos in account numbers, incorrect vesting dates for stocks, or missing debt assignments, happen in the final 60 minutes of the session. The goal of winning the peace is to ensure that the day you sign that decree is the last day you ever have to deal with the legal system. You are closing the book on the conflict so that you can open the book on your independence. A successful settlement is one where you feel a sense of relief, not because you won every point, but because you have certainty. You know what your bank account will look like, you know where your children will sleep, and you know that the law is on your side to enforce those terms. But even with a perfect settlement in hand, there is a final invisible hurdle. The divorce is legal, the assets are divided, but your identity is still tethered to the past. How do you actually rebuild in a U.S. economy that is often biased against single women? How do you repair your credit score, re-enter the workforce at a higher level, and navigate the social shift of being a divorced woman in 2026? In the next part, we are going to pivot from the legalities to the reconstruction. We will explore the post-divorce financial reset, the psychology of identity reclamation, and the specific steps to building a new social and professional network from scratch. The settlement was the end of the war, but the reconstruction is where you actually start living. In Part 9, we build the blueprint for your new empire. The legal decree is signed, the assets are transferred, and for the first time in years, the noise of litigation has fallen silent. However, for many women in the United States in 2026, this silence can be deafening. The reconstruction phase is not merely about moving into a new apartment. It is a systematic rebuilding of your financial, professional, and social infrastructure. Historical trends show that the first 24 months post-divorce are the most volatile for a woman's wealth and credit standing. To build your new empire, you must approach this period with the same tactical precision you used during the discovery phase. This is the stage where you transition from being a litigant to being the chief executive officer of your own life. Imagine the scenario of Diana, a woman in Charlotte who finalized her divorce in early 2026. For 12 years, her credit profile was inextricably linked to her spouse. They had a joint mortgage, joint credit cards, and a shared history of utility payments. When the divorce was finalized, Diana realized that while she had received a significant settlement in liquid assets, her individual credit score was surprisingly low because she lacked a diverse history of accounts in her name only. This is a common hurdle in the US, where the credit bureaus view a newly single individual as a fresh, and therefore risky, entity. Diana's reconstruction began not with spending her settlement, but with a deliberate strategy to establish her independent financial identity. The first pillar of your empire is the credit score restoration. In the US economy of 2026, your credit score dictates the interest rates on your new car, the premiums on your insurance, and even your ability to pass a background check for a high-level job. Step by step, you must ensure that your name is removed from every joint debt mentioned in your decree. A common mistake is assuming that because the judge ordered your ex-spouse to pay a certain credit card, you are protected. In the eyes of the bank, if your name is on the contract, you are liable. You must verify that those accounts are closed or refinanced. Simultaneously, you should open a secured credit card or a credit builder loan if your score has dipped. By making small, consistent payments, you are signaling to the financial system that you are a reliable, independent borrower. The second pillar is the vocational reentry or pivot. If you have been out of the workforce or working in a diminished capacity during your marriage, the 2026 job market can feel like a foreign landscape. Historical trends in the US indicate that women who pursue upskilling or specialized certifications within the first year of divorce see significantly better potential outcomes in their long-term earning capacity. Step by step, you should also establish a new professional network. The social circles of a marriage often fragment after a split. You may find that friends you shared as a couple feel forced to choose sides, or that the dynamic has changed so much it feels awkward. In 2026, many women are joining professional organizations or female-focused investment clubs to build a network that has no ties to their past. These environments provide more than just social interaction. They offer mentorship and access to opportunities that are vital for your reconstruction. You are not just looking for friends. You are looking for allies who see you as the woman you are becoming, not the wife you were. Now, let's look at the housing and environmental psychology of reconstruction. Whether you stayed in the family home or moved to a new space, your environment must reflect your new reality. As you stand in your new home, looking at a bank account that is yours and yours alone, you realize that the hard part is over. But there is one final piece of the puzzle. How do you ensure that you never find yourself in this position again? How do you protect your new empire as you eventually re-enter the world of dating and potential remarriage? The century of change has taught us that the best way to preserve your independence is to plan for its protection from the very beginning. In the final part of our masterclass, we are going to look at the future-proofing of your life. We will discuss the modern U.S. prenuptial and postnuptial agreements of 2026, the rise of the Independence Clause, and how to maintain your separate property in future relationships. We will conclude with the ultimate checklist for the century of change woman. Part 10 is about making sure your new empire lasts a lifetime. The final stage of this masterclass focuses on future-proofing and the preservation of the autonomy you have worked so hard to regain. In the United States in 2026, the concept of marriage is being redefined by a generation of women who have seen the volatility of the legal system firsthand. Historical trends suggest that second and third marriages have a higher statistical probability of dissolution than first marriages. Therefore, protecting your new empire is not an act of pessimism. It is an act of sophisticated financial stewardship. We are moving away from the era of accidental liability and into an era of intentional partnership. Imagine the scenario of Catherine, a business owner in Seattle who successfully navigated a divorce in 2024. By 2026, Catherine has rebuilt her wealth, expanded her company, and met a new partner. Unlike her first marriage, Catherine approaches this relationship with a clear understanding of separate property maintenance. She understands that in the U.S., the commingling of assets is the primary way women lose their independent wealth. This is the case study for the modern woman. She loves with her heart but protects with her balance sheet. The first step in future-proofing is the implementation of a modern prenuptial agreement. In the century of change, prenups are no longer just for the ultra-wealthy. They are for anyone with a retirement account, a home, or a professional degree. A 2026 prenuptial agreement in the U.S. often includes what is known as an independence clause. This clause specifies that any appreciation in the value of a premarital business or property remains separate property, even if marital funds are used for its upkeep. It can also include a lifestyle clause, which addresses things like social media privacy and the division of household labor, though the enforceability of lifestyle clauses varies by state. Step by step, you should introduce the topic of a prenup early in a serious relationship, framing it as a tool for transparency and mutual protection. Next, we must look at the mechanics of separate property management. Even with a prenup, you can inadvertently lose your assets through commingling. If you use your separate inheritance to pay for a joint vacation, that money is likely gone. If you deposit your separate rental income into a joint checking account, it can become marital property. Historical trends in U.S. case law show that the burden of proof is always on the person claiming the property is separate. You must maintain what is known as a clean paper trail. This means keeping separate bank and brokerage accounts for your premarital assets, and never mixing those funds with marital income or expenses. In 2026, digital banking makes this easier, but it requires a level of discipline that many find difficult to maintain in the honeymoon phase of a new relationship. The third pillar of future-proofing is the strategic use of trusts. For women with significant assets or children from a previous marriage, a revocable living trust or an irrevocable trust can provide a layer of protection that a prenup alone cannot. By placing your assets into a trust before a second marriage, you remove them from your personal balance sheet. In the event of a future divorce or your passing, the assets are distributed according to the terms of the trust, not the default laws of the state. This is a common strategy in the U.S. for ensuring that your children's inheritance is protected from a future spouse's potential claims. Now, let us examine the ultimate checklist for the century of change woman. This is your operational manual for the years following your divorce. Step 1. Conduct an annual financial audit. Every January, review your net worth, your credit score, and your asset allocation. Ensure that your emergency fund is fully funded and that your retirement contributions are maximized. Step 2. Update your estate plan every 3 to 5 years, or whenever a major life event occurs. Step 3. Maintain your professional edge. Never allow your skills to become obsolete. In the rapidly evolving economy of 2026, continuous learning is your best insurance policy against financial dependency. We also have to discuss the social and emotional future-proofing. Historical trends show that women who maintain a strong, independent social network outside of their primary relationship are more resilient and have higher levels of life satisfaction. Do not allow your world to shrink to the size of your partner's world. Invest in your friendships, your hobbies, and your community involvement. This social capital is an intangible asset that provides a safety net that money cannot buy. Another modern reality is the rise of the postnuptial agreement. If you are already in a new marriage and realize you didn't protect your assets sufficiently, a postnup can be a powerful tool. In the U.S., postnups are treated with more scrutiny by courts than prenups, but they are increasingly common for couples who experience a change in financial circumstances, such as a large inheritance or the launch of a successful business. A postnup allows you to define what is separate and what is marital while the relationship is still healthy, preventing a catastrophic legal battle later. Case studies of successful second marriages in 2026 frequently highlight the importance of financial transparency. This means having regular money meetings where both partners discuss their individual and joint goals. In the U.S., financial infidelity remains a leading cause of divorce. By being open about debts, income, and spending habits from day one, you build a foundation of trust that is far more durable than one built on secrets. You are not just protecting yourself, you are protecting the integrity of the partnership. As we conclude this 10-part masterclass, we look back at the century of change. 100 years ago, a woman's survival was tied to her marital status. Today, your survival and your success are tied to your information, your strategy, and your resolve. You have traveled from the initial shock of the disclaimer and the hook, through the deep trenches of financial audits, custody battles, and psychological warfare, to the reconstruction of your identity and the future-proofing of your empire. The potential outcomes for your life are now wider and brighter than ever before. You are part of a historical trend of women who refuse to be defined by their endings. Instead, you are defined by your ability to navigate transition with grace and intelligence. The U.S. legal and financial system is complex, and it can be adversarial, but it is also a system that you now know how to use to your advantage. The blueprint for your new life is in your hands. You have the spreadsheets, the legal frameworks, and the psychological armor. You have the data to back up your decisions and the history to remind you of your strength. This masterclass was designed to give you the depth that a simple summary could never provide. You didn't just want the answers, you wanted the understanding. And with that understanding comes the power to build something that lasts. As you move forward into 2026 and beyond, remember that the most important asset you own is your own agency. Guard it fiercely, use it wisely, and never forget the journey it took to reclaim it. Your empire is not just about the money in the bank or the deed to the house. It is about the peace of mind that comes from knowing you are the master of your own fate. This concludes our deep dive masterclass on the century of change. Your new beginning starts today.